Hey guys, so here we are in the second part of the fundamental rights of the Indian Constitution. So let's get to know about the rest of the articles. Article 23 to 24, Right against exploitation. Article 23, Prohibition of traffic in human beings and forced labor. The protection of this article is available to both citizens as well as non-citizens. Article 23 clause 1 says that traffic in human beings and beggar and other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offence punishable in accordance with law. Article 23 clause 2 is the compulsory service for public purposes. Clause 2 of Article 23 contains an exception to the above general rule. Under this clause, the state is empowered to impose compulsory services for public purposes. But in imposing such compulsory service, the state cannot make any discrimination on ground only of religion, race, caste, or class, or any of them. For example, compulsory military services or social services can be imposed because they are neither beggar nor traffic in human beings. Article 24, Prohibition of employment of children in factories, etc. It prohibits the employment of children below 14 years of age in factories and hazardous employment. If we look into MC Mehta vs. State of Tamil Nadu case, the Supreme Court has held that children below the age of 14 years cannot be employed in any hazardous industry, mines, or other works, and has laid down exhaustive guidelines how the state authorities should protect economic, social, and humanitarian rights of millions of children working illegally in public and private sections. This matter was brought by MC Mehta by public interest litigation under Article 32 of the Constitution. He told the court about the plight of the children engaged in Sivakasi cracker factory. That's all about Article 23 and 24, Right against exploitation. And now let's get into Article 25 to 27, Freedom of religion. It explains Article 25, freedom of conscience and the right to profess, practice, and propagate religion. The expression freedom of conscience means the inner freedom of a person to mold his relations with his God in whatever way he likes. The word profess means to allow publicity or to declare openly one's own faith or belief in. The expression practice of religion signifies acts done in pursuance of religious belief. Article 25 clause 2 says that nothing in this article shall affect the operation of any existing law or prevent the state from making law, subclause A, regulating or restricting any economic, financial, political or other secular activities which may be associated with religious practice, and subclause B, providing for social welfare and reform or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Article 26, Freedom of religious denominations. Freedom to manage religious affairs subjected to public order, morality and health. Every religious denomination or any section thereof shall have the right. Article 26 clause A is a right to establish and maintain. It is to establish and maintain institutions for religious and charitable purposes. Article 26 clause B is the right to manage matters of religion. It guarantees to every religious denomination the right to manage its own affairs in matters of religion. The expressions matters of religion includes religious practices, rites and ceremonies essential for the practicing of religion. Article 26 clause C is the right to own and administer property. It guarantees the right to own and acquire movable and immovable property. Article 27 is the freedom from payment of taxes for promotion of any particular religion. It provides no person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. It may be noted that Article 27 prohibits the levy of a tax and not the imposition of a fee. If we look into B.K. Dev vs. State of Orissa case, it has been observed that where the state granted money for renovation of water tank belonging to Lord Jagannath but used by the general public for bathing and drinking purposes, it is not violative of Article 27 because in such circumstances the state could not be taken to have promoted or maintained the Hindu religion as the tank is used for public and its renovation is necessary to maintain the hygiene. Now let's discuss about Article 28. Article 28 is the freedom as to attendance at religious instruction or religious worship in certain educational institutions. Article 28 Clause 1 provides that no religious instructions shall be provided in any educational institution wholly maintained out of state funds. Article 28 Clause 2 is an exception to Clause 1 which provides that Clause 1 wouldn't apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution. If we look into DAV College vs. State of Punjab case, the Supreme Court has observed that the provision for an academic study of the life and teachings of great saint of India in relation to India and world civilization couldn't be considered as providing for religious and philosophical studies. Article 28 Clause 3 says that no person attending any educational institution recognized by the state or receiving aid out of state funds shall be required to take part in any religious instruction that may be imparted in such institutions or to attend any religious worship that may be conducted in such institution or in any premises attached thereto, unless such person or if such person is a minor, his guardian has given his consent thereto cultural and educational rights. That was the end of Article 25 to 27 Freedom of Religion and Article 28, and let's get into Article 29 to 30 Cultural and Educational Rights of Minorities. Article 29 is the protection of interests of minorities. Article 29 Clause 1 says that any section of the citizens residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. Article 29 Clause 2 says that no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, caste, race, language or any of them. Article 30 is the right of minorities to establish and administer educational institutions. Article 30 Clause 1 says that all minorities, whether based on religion or language, shall have right to establish and administer educational institutions of their choice. Article 30 Clause 1a says that in making any law providing for the compulsory acquisition of any property of an educational institution established and administered by a minority, the state shall ensure that the amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed. Article 30 Clause 2 says that the state shall not, in granting aid to educational institutions, discriminate against any educational institution on the ground that is under the management of a minority, whether based on religion or language. If we look into A.M. Patroni vs. E.C. Kesavan case, it has been observed that any community, religious or linguistic, numerically less than 50% of the population of the state is a minority community. Let's not get into the details of Articles 31A, 31B and 31C, but let's just mention them. Article 31A is the savings of laws providing for acquisition of estates. Article 31B is the validation of certain acts and regulations. Article 31C is the saving of laws giving effect to certain directive principles. And Article 31D is the saving laws in respect of anti-national activities. Now let's discuss about the most important topic of the fundamental rights, Article 32, Right to Constitutional Remedies. Article 32 of the Indian Constitution gives the right to individuals to move the Supreme Court to seek justice when they feel that their right has been unduly deprived. The apex court is given the authority to issue directions or orders for the execution of any of the rights bestowed by the Constitution, as it is considered the protector and the guarantor of fundamental rights. There are 5 types of writs as provided under Article 32 of the Constitution. 1. Habeas corpus. It is one of the important writs for personal liberty which says you have the body. The main purpose of this writ is to seek relief from the unlawful detention of an individual. Writ of habeas corpus is issued if an individual is kept in jail or under a private care without any authority of law. A criminal who is convicted has the right to seek the assistance of the court by filing an application for writ of habeas corpus if he believes that he has been wrongfully imprisoned and the conditions in which he has been held falls below minimum legal standards for human treatment. The first habeas corpus case of India was that in Kerala, where it was filed by the victim's father as the victim P. Rajan, who was a college student, was arrested by the Kerala police and being unable to bear the torture, he died in police custody. So his father, Mr. T. V. Ichara Warrior, filed a writ of habeas corpus and it was proved that he had died in police custody. 2. Quo Warranto. Writ of Quo Warranto implies thereby by what means. This writ is invoked in cases of public offices and it is issued to restrain persons from acting in public office to which he is not entitled to. Appointment to public office can be challenged by any person irrespective of the fact whether his fundamental or any legal right has been infringed or not. The court issues the writ of Quo Warranto in the following cases. A. When the public office is in question and it is of a substantive matter, a petition against a private corporation cannot be filed. The office is created by the state or the constitution. And C. The claim should be asserted on the office by the public servant, that is, respondent. 3. Writ of mandamus. Writ of mandamus means we command in Latin. This writ is issued for the correct performance of mandatory and purely ministerial duties and is issued by a superior court to a lower court or government officer. However, this writ cannot be issued against the president and the governor. Its main purpose is to ensure that the powers or duties are not misused by the administration or the executive and are fulfilled duly. Also, it safeguards the public from the misuse of authority by the administrative bodies. Conditions for issue of mandamus. A. There must rest a legal right of the applicant for the performance of the legal duty. B. The nature of the duty must be public. C. On the date of the petition, the right which is sought to be enforced must be subsisting. And D. The writ of mandamus is not issued for anticipatory injury, which means a predicted injury. 4. Writ of certiorari. Writ of certiorari means to be certified. It is issued when there is a wrongful exercise of the jurisdiction and the decision of the case is based on it. The writ cannot be moved to higher courts like the High Court or the Supreme Court by the affected parties. It is issued to quasi-judicial or subordinate courts if they act in the following ways. A. Either without any jurisdiction or in excess. B. In violation of the principles of natural justice. C. In opposition to the procedure established by law. and D. if there is an error in judgment on the face of it. If we look into Surya Dev Rai versus Ramchandar Rai and O's, the Supreme Court has explained the meaning, ambit and scope of the writ of certiorari. Also, in this, it was explained that certiorari is always available against inferior courts and not against equal or higher courts. That is, it cannot be issued by High Court against any High Court or benches, much less to Supreme Court and any of its benches. And 5. Writ of Prohibition. It is a writ directing a lower court to stop doing something which the law prohibits it from doing. Its main purpose is to prevent an inferior court from exceeding its jurisdiction or from acting contrary to the rules of natural justice. It is issued to a lower or a subordinate court by the superior courts in order to refrain it from doing something which it is not supposed to do as per law. It is usually issued when the lower courts act in excess of their jurisdiction. Also, it can be issued if the court acts outside its jurisdiction. Article 32 gives teeth to the fundamental rights given to us in the Constitution. According to Article 32, in case of violation of any of our fundamental rights by state or individual, we can directly knock the doors of the Supreme Court. Similarly, Article 226 gives us right to go to the state's High Court in case of violation of our fundamental rights, which would be given special attention by the judges by issuing the writs and restoring our rights. Fundamental rights would have no real value if this article was not there, and that is why it is called as heart and soul of our Constitution by Dr.B.R.Ambedkar. That was the end of Article 32, and let's discuss about Article 33, Restriction of Fundamental Rights of Armed Forces. Parliament may by law determine to what extent any of the rights conferred by this part in their application to the members of the armed forces or the members of the forces charged with the maintenance of public order or persons employed in any bureau or other organization established by the state for purposes of intelligence or counterintelligence, or person employed in or in connection with the telecommunication systems set up for the purposes of any force, bureau or organization referred in clauses A to C, and be restricted or abrogated so as to ensure the proper discharge of their duties and the maintenance of discipline among them. And Article 34 is a restriction on rights conferred by this part while martial law is in force in any area. It simply means that Article 34 is an enabling provision to allow Parliament to pass laws indemnifying the armed forces against prosecution for any acts they may have committed when martial law is in force. Otherwise, the armed forces would never return power. And Article 35 is the legislation to give effect to the provisions of this part. With this, we have come to an end of the video of fundamental rights with the most important parts discussed. And I also thank Team Kala for giving me this wonderful opportunity. Thank you guys. Stay strong and stay active.